Welcome back to our Legal English series. Today, we're jumping into a topic that shows up in almost every law office and HR department: employment contracts and terms. Whether you're reviewing a client's severance package, drafting a non-compete clause, or explaining at-will employment, the terms you use matter, and so does how you explain them. In this lesson, you'll build the vocabulary and grammar tools to talk confidently about employment terms in a legal setting. Here's what we're focusing on today. First, we'll review key vocabulary terms that come up constantly in employment law: at will, non-compete, and severance. Then we'll look at grammar structures that show up in contracts, especially verb patterns like agree to work, refuse to sign, and how they affect meaning. You'll also learn to tell the difference between defining and non-defining clauses, a subtle but important skill when reviewing or drafting contract language. By the end of this lesson, you'll be able to explain the basics of employment contracts in clear, professional English, just like you would do to a client. Let's start with a simple question that opens up a lot of legal ground. What do you agree to when you sign an employment contract? Of course, there's the obvious: your job title, your hours, and your salary. But that's just the beginning. In most professional contracts, you'll find clauses that deal with how and when someone can be fired. That's what we call termination rules. There might also be confidentiality clauses to protect company information, or non-compete agreements that limit where someone can work after they leave. As lawyers, our job is to understand these terms, explain them clearly to clients, and spot problems before they become legal disputes. So in this lesson, we're going to dig into these key terms, what they mean, how they're structured, and how to talk about them like a legal professional in English. Let's begin with a key concept in employment law: at-will employment. In an at-will arrangement, either the employee or the employer can end the working relationship at any time for almost any reason, and they don't have to give advance notice. This is standard in many U.S. states, not so much in Costa Rica. You'll often hear employment is at will unless a contract says otherwise. But here's something important. This is very different from how it works in Costa Rica and many civil law countries in the region. For example, the default rule here is job stability and employee protection. Employees must justify terminations, give proper notice or severance, and follow strict labor codes. So, at-will employment is not recognized here. You can't just fire someone because you feel like it. So, if a Costa Rican client asks, "Can I let this person go, this employee go tomorrow?" As a lawyer, you need to look at whether just cause exists and whether notice or severance is required under local labor law. Understanding the difference between at-will systems like the United States and contract-based or statutory systems like Costa Rica is essential when advising clients. Now, let's look at another common clause in employment contracts: non-compete. A non-compete is a clause that restricts the employee's ability to work for a competitor or start a similar business after leaving a job. So, if someone says the company asked all executives to sign a non-compete agreement, it means those executives agreed not to take similar jobs or open competing firms, usually for a certain time period and within a specific location. These are very common in the United States, especially for higher level employees or people with access to confidential information. Employers use them to protect trade secrets, client lists, and competitive strategies. But now, let's compare that with Costa Rican labor law and many countries in the region. In Costa Rica, non-compete clauses are extremely limited, they're generally only enforceable during the post-employment period if the employer pays compensation, usually 50% of the former salary for the duration of the restriction. And even then, they must be reasonable in time and scope. So, a U.S. client may expect to include strict non-compete terms in a contract, but here in Costa Rica and other countries in the region, you'll have to explain that clause won't be valid unless you compensate the employee and keep it narrowly defined. Understanding these legal and cultural differences is key when reviewing or drafting international employment contracts. Let's finish this vocabulary section with a key term in both common law and civil law systems: severance. Severance refers to the compensation an employee receives when their employment is terminated, especially when it happens through no fault of their own, like layoffs or organizational restructuring. So, in English, you might hear, the terminated employees receive severance based on their years of service. This type of payment helps employees transition financially while they look for a new job. In some countries, it's optional or negotiated. In other countries, it's mandatory. Now, let's look at Costa Rica. In Costa Rica, severance is not optional. It's part of the worker's legal rights under the labor code. If an employee is dismissed without just cause, the employer must pay. A pre-notice payment or work through a notice period, proportional Christmas bonus, which you know as aguinaldo, unused vacation days, and a severance payment, they call cesantía here, calculated based on the length of the time the employee worked for the company. And here's the key difference. In the U.S., severance is often negotiated or offered in exchange for signing a release. In Costa Rica, it's automatically owed unless the termination is for just cause. So, if you're helping an international client who wants to end a labor relationship here in Costa Rica, you'll need to calculate severance correctly and also explain it to the client correctly and make sure the dismissal follows local law. It's a great example of how legal vocabulary connects to practical legal duties, especially across borders. Let's now talk about one of the core legal elements that defines whether a relationship is truly employment: subordination. In legal terms, subordination means the condition in which the worker is under the direction and control of the employer. The employer decides what work is done, when, and how, and the worker follows those instructions. In plain terms, if someone tells you what time to show up, what to do, and how to do it, you're in a subordinate relationship. For example, a key sign of an employment relationship is subordination. The employer sets the schedule and supervises the work. Now let's take a local example here in Costa Rica. Subordination is one of the three essential elements of a labor relationship, the other two being personal service and remuneration, or payment. And this is where the principle of reality comes into play. Even if the written contract says this is an independent contractor, if the worker is under constant supervision, works a fixed schedule, and uses the company's tools, Costa Rican courts may decide this is actually a labor relationship. So, as a legal professional, recognizing subordination means looking at how much control the employer exercises, because that control often determines the employer's legal obligations. And now let's close with the third key element of employment relationships: personal service. This term means the work has to be done by the specific person hired. It cannot be handed off to someone else. So the service is tied to the individual, not just the result. In legal English, we might say the contract required personal service, meaning only the named consultant could do the work. This is especially important when the job depends on personal skills or trust. For example, hiring a lawyer, a private chef, or a software developer. Now, how does this apply under Costa Rican labor law? Personal service is one of the three pillars that define an employment relationship. If a person performs the work personally, receives payment, and is under subordination, then legally it's considered an employment contract, even if the paperwork, the contract, says otherwise. So, if an employer signs an agreement with a contractor, but that person shows up every day, works under supervision, and can't send someone else to replace them, that's personal service. And that triggers legal obligations, minimum wage, Social Security, paid vacation, and more. Bottom line, if you're advising a client on whether a relationship is labor or civil, look closely at this. Is the work personal and non-transferable? That one question can completely change the legal outcome. Let's begin with a fundamental legal principle, substance over form. This means that in employment law, what really matters is how the work is done in practice, not just what the written contract states. For example, if a contract says this is an independent contract agreement, but the worker is controlled like an employee, working set hours, following directions, the courts will look beyond the words. They ask, what is the true nature of this relationship? That's substance over form. In Costa Rica, this principle is crucial because labor laws protect workers who are effectively employees, even if the paperwork tries to classify them differently. So, when advising clients or reviewing contracts, always focus on the actual working conditions and not just the label. This ensures compliance with labor law and avoids costly disputes. Next, let's talk about a common type of employment agreement, the fixed-term contract. This is simply a contract that specifies exact dates for the employment to start and end. For example, from January 1st to June 30th. Fixed-term contracts are often used for temporary projects or seasonal work. In Costa Rica, fixed-term contracts are legally valid, but they come with specific rules. Employers cannot keep renewing these contracts indefinitely without risking the contract being treated as permanent. The law also requires a clear reason for the contract's limited duration, like a temporary replacement or a special project. Understanding fixed-term contracts helps lawyers explain employment terms clearly and helps clients avoid misunderstandings or legal risks. Let's move on to a crucial aspect of ending an employment relationship: termination notice. This is the formal communication from employer to employee, or vice versa, that the job will end. Termination notice periods vary by law and contract, but their purpose is clear: to give time for preparation, whether to find a new job or a replacement. In Costa Rica, labor law requires employers to provide advance notice before terminating the employment without cause. Failing to give proper notice can mean paying compensation in lieu of notice. So knowing how and when to give termination notice protects both parties and ensures a professional, legally compliant exit process. Now, let's define the heart, the most important part of labor law, the labor relationship. This means a working relationship characterized by three core elements, which we've talked about: subordination, the worker follows the employer's direction. Payment, the worker receives wages or salary. And personal service, the work is done by the individual, not delegated to someone else. If all these are present, legally, there's a labor relationship, which triggers labor protections like Social Security, vacation, and severance rights. In Costa Rica and other countries in the region, this is the foundation of labor law enforcement. Even if a contract says independent contractor, the court looks at these legal elements to decide if labor law applies. As legal professionals, understanding this helps you advise clients on contracts, employment disputes, and compliance. Finally, let's clarify the concept of independent contractor. An independent contractor is someone hired to provide specific services, but who operates independently from the employer. Key features include the control over how and when they work, using their own tools or resources, no subordination to the employer. This differs with an employee who works under the employer's direction and is covered by labor laws. In Costa Rica, the difference between an independent contractor and an employee is critical because labor laws apply only to employees. Remember, simply calling someone an independent contractor in a contract doesn't guarantee that legal status. Courts examine the reality, applying the substance over form principle we discussed earlier. So always analyze the facts carefully to determine the correct classification and legal obligations. Now, imagine a company hires a project manager for exactly 1 year to oversee a big construction project. The contract clearly states the start and end dates, no surprises, no automatic extensions. This setup is common when employers need someone for a specific period or task. What's the legal term for this kind of agreement? The answer is fixed term contract. This means the contract has a clearly defined start and end date. A senior sales executive leaves a company but agrees not to work for any rival firms for the next year. This protects the original employer's confidential information and client relationships. Such clauses are common in industries where competition is fierce. What do we call this kind of agreement? The answer is non-compete. It limits where employees can work after leaving. After years of service, a company informs an employee in writing that their contract will end in 30 days. This period gives the employee time to prepare and look for other opportunities. It's a legal requirement in many countries to ensure fair treatment. What is this formal communication called? Exactly. Termination notice, a formal notice that an employment relationship will end. Let's look at another one. When an employee is let go, the company offers extra pay or benefits to help during the transition. This compensation can help cover expenses until the employee finds a new job. Severance packages vary depending on contract terms and local laws. What's the legal term for this kind of payment? Severance. Exactly. It's money or benefits given after employment ends. Let's talk about something that comes up all the time in contracts and legal conversations. Verb patterns. Now, what do I mean by that? Well, some verbs are followed by a specific structure. For example, you might say, she agreed to sign the contract, not agreed signing. That sounds off. It doesn't sound right. And some verbs follow completely different patterns. In legal English, using the right pattern makes your sentence precise, natural, and professional. Let's look at the three most important types you'll see in contracts and legal writing. Let's look at these common patterns, like the verbs agree or refuse. They're followed by to plus verb. For example, the employee refused to accept the severance terms. That's the structure. Refuse to accept, not refuse accepting. Other verbs like consider or avoid need the ing form. For example, they avoided triggering a labor relationship. Again, if you said it avoided to trigger, it wouldn't sound right. These choices aren't random. They're built into how English works. But once you learn the pattern, it becomes automatic. Now, here's another pattern that's especially common in legal writing. Verbs like require, advise, or allow often follow this format. Verb plus object plus to plus verb. For example, the contract required her to give termination notice. See that structure? The verb is required, the object is her, and the action is to give notice. This is one of the most precise and professional ways to assign responsibility in legal documents. You're not just saying what needs to happen, you're saying who needs to do it and what they need to do. Why does it matter? Because using the wrong pattern sounds unnatural and can confuse the meaning in contracts or negotiations. Let's talk about something lawyers use in almost every contract: relative clauses. They help us describe a person, a clause, or a condition with precision. And in legal English, that's everything. There are two types. A defining relative clause tells us exactly which thing we're talking about. For example, the employee who signed the contract started work on Monday. Now, a non-defining clause adds extra information, but it is not essential. It is not vital. For example, the client who arrived late missed the hearing. We'll go deeper into how and when to use each one. Remember, when the information is essential, meaning it tells exactly which person or thing we're talking about, we use a defining relative clause. That means no commas because the clause is part of the core sentence. Look at this example. The witness who gave testimony was credible. We're not just talking about any witness, we're talking about the one who gave testimony. That clause helps us define who we're referring to. This structure is key in contracts where precision is everything. Now, let's talk about non-defining clauses. They give us extra information. They're helpful, but not essential to understand the sentence. And grammatically, in writing, we show that with commas. For example, the lawyer whose office is in San Jose specializes in labor law. Even without the clause, the sentence still works. The lawyer specializes in labor law. We just added detail that his or her office is in San Jose. Non-defining clauses sound more formal, and they're used a lot in reports, legal memos, and witness statements. And here's a tip. In this kind of clause, we don't use that. We stick with who, which, or whose. Now let's get into my favorite part, idioms. Let's start with the idiom, bite the bullet. This phrase means you accept something tough or unpleasant, even though it's hard. In labor law, this can come up when someone is faced with job cuts, contract changes, or just a tough decision. Picture this. Your company is downsizing. You've been offered a severance deal. You don't love it, but waiting might be worse. You decide to just bite the bullet and accept it. It's about being brave in a tough moment. Here's another one. Throw in the towel. It comes from boxing, when a trainer throws a towel into the ring to stop the fight. In legal English, it's used when someone gives up, especially after a long negotiation or dispute. Maybe a union fights for better wages, but management won't budge. Eventually, the union throws in the towel. They stop negotiating. In law, this idiom often shows up when one party has no more options. Now, this idiom, hit the ground running, is all about starting strong. It means someone jumps into a project or job immediately and with full energy. Let's say a new lawyer joins your firm. On her first day, she's already drafting contracts and leading calls. She didn't waste any time. That means she hit the ground running. In the legal world, this phrase is often used to describe people who don't need much training. They're ready to go. And finally, let's talk about call the shots. This idiom means to be the one in charge. The person makes the big decisions. In a company, the board of directors usually calls the shots on things like budgets, hiring CEOs, or approving mergers. If you're the one setting the direction, you're calling the shots. It's a useful idiom for describing power dynamics in the workplace. So now let's wrap up with a big picture look at labor law, and specifically labor law in Costa Rica as an example. As a labor lawyer, this is the kind of language you'll need to explain to clients, both employers and employees. First, the labor code is your go-to reference. It's designed to protect both sides, but employers need to be especially careful about compliance. Contracts are essential. Unlike in the United States, where at-will employment can end at any time, in Costa Rica, a written contract is critical. It defines the terms, the limits, and obligations. Work hours in Costa Rica, the law generally sets a maximum of 48 hours per week, and overtime isn't optional. It must be paid fairly. Benefits are broad. Vacation, sick leave, and 4 months of maternity leave are guaranteed by law. And let's not forget the Caja. That's the national security system. Every employer has to contribute. So what happens if these rules aren't followed? You're looking at fines, court cases, and serious damage to your company's name. This is why legal guidance is so valuable in employment relationships in Costa Rica and across the world. Great work today. We covered a lot of ground, and all of it is essential for lawyers working in labor and employment law. First, you learned key vocabulary that comes up in contracts, words like at will, non-compete, and severance. These aren't just terms. They define how someone's job begins and how it can end. Then we focused on grammar that really matters in legal writing and speaking, verb patterns, and relative clauses. These tools help you sound clear, accurate, and professional. Now, it's more than anything, you practice how to talk confidently about employment relationships, the kind of language lawyers use every day to protect their clients' rights and avoid future disputes. This is the foundation of solid legal advice, and it's what makes you a trusted legal communicator. Great job, and see you in the next lesson.